Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 6 of term 2 2017. Tonight we're dealing with arbitration. Arbitration is not something that you will encounter as commonly as you will mediation or conciliation, but still very important, and for those of you that practice in arbitration, critically important. So you'll recall from the outset when we discussed the continuum of alternatives in alternative dispute resolution on page 3 of your text, the chart which indicates the most formal and the least formal, from 1 to 14, 1 being negotiation. Well, today we're at the opposite end of the spectrum. Arbitration is number 14, meaning that it's the most formal, it's the most non-consensual, and it's the most interventionist of all the alternative dispute resolution procedures that we'll cover during this course. In other words, it's most court-like. However, it retains a considerable degree of flexibility, and the parties to an arbitration agreement have an opportunity to mould the terms of the arbitration agreement as they see fit in many ways. Arbitrators can, depending on the nature of the power conferred on them through the agreement, adopt an inquisitorial process. They can arbitrate with or without pleadings, or they can conduct a hearing, which is typically what happens, but there is an alternative for the arbitration to be conducted on the papers, that is, without a hearing itself. So what we're gathering so far is that arbitration is in many ways very similar to litigation. It's very similar in terms of representation and advocacy. Lawyers are very typically involved in arbitration. They may not be so involved in other areas. And arbitration can, at its most formal, include many things that we see in litigation: pleadings, interlocutory procedures, evidence given in effect at an arbitration, somewhat similar to that of a trial, and a decision of a third party, the arbitrator. We call that decision an award rather than an order or a decision of the court. But you'll see that there are many similarities if we adopt that most formal of the options available in an arbitration proceeding. So arbitration in Australia has a long history. It goes way back to the Constitution, and there are unusual features in arbitration in that it is steeped in that history. However, arbitration, as we talk about it now, is different in its nature and its constitution to that which was created back at the turn of the century, last century. So arbitration now is in essentially two forms: international or domestic. The background to all of this is the UNCITRAL, that's United Nations. It's the UNCITRAL is the acronym, Model on International Commercial Arbitration. That's the United Nations Commission on International Trade Law is UNCITRAL. So in your reading, you'll see reference to the model, and the model law, which comes through that body, is designed to assist states in reforming and modernising their laws on arbitral procedures. And in Australia, we have adopted those procedures. And the model law, which deals primarily with international commercial arbitration, but which filters through to domestic level in other forms of arbitration, deals with the whole process. So it might deal with the arbitration agreement, it might deal with the composition and the jurisdiction of the arbitral tribunal, and it may have some effect on the extent of the court intervention through the recognition and enforcement of the arbitral award. So the best place to look for information about that, apart from the textbooks, is the United Nations Commission on International Trade Law. There's a website that you can access in that regard. So far, we've picked up that arbitration is similar to court in many ways. We've identified that it has an international flavour about it, and we've identified that it has a commercial flavour about it. So when we're talking about arbitration, we tend to think of commercial matters, but it's not limited to that. And as Spencer points out, if you remove the word commercial from the main domestic act, it would still work. So consumer transactions can also be the subject of arbitration or arbitral proceedings. I guess as a practical thing, just out of interest, have a look at the fine print in some of the acquisitions that you've made, whether it's a computer or something else, and you may find that there is an agreement that you've entered into that any dispute be referred to arbitration. But typically, arbitration can involve commercial projects, some large projects, some projects that are international, and it may be quite common for a large-scale alternative dispute resolution agreement to provide for arbitration, and the arbitration may well be conducted in a neutral country. So if we're dealing with an international arrangement involving Australia, Singapore, and another country, it may be that the arbitration is ultimately conducted in, say, Hong Kong. So there are different options available, if you like, at that level. But let's bring it down a level to more the domestic situation. If you're looking for a definition of arbitration, there are plenty, but I guess you've become accustomed to looking at the NADRAC definition. And even though NADRAC doesn't exist in its original form, it still has an effect which is persuasive in the ADR industry. So what does NADRAC say about arbitration? It says, arbitration is a process in which the parties to a dispute present arguments and present evidence to a dispute resolution practitioner, that is the arbitrator, who decides. Sounds like court, doesn't it? And as indicated, when the arbitrator makes the decision, that decision is called an award. So there are some key features of arbitration, things that you take from that definition. The first is that it's private. Second is it can be voluntary or it can be mandatory. It can be mandatory. The Supreme Court may refer the matter to arbitration. But the key feature, of course, is that we have an impartial third party, the arbitrator, who makes a decision based on law. Now, the arbitrator is not a judge, not a tribunal member, not a person who's appointed through government in a sense. It's a party that's selected by the individuals to the dispute. So the parties select the arbitrator, usually. And the arbitrator is very often an expert in the field of the dispute. It might be a barrister, it might be a retired judge, it might be an engineer, or it might be some other person who has, if you like, a special expertise in the field under discussion or under dispute. So there are many similarities between arbitration and litigation. It can be, and very often is, adversarial, in the sense that the parties line up their respective cases in arbitration and meet at the end. You see, and that's an odd part about our arbitration, in that it runs, if you like, counter to the philosophy of many of the ADR practices that we have become used to, where there's a requirement for the parties to come together at an early stage. Arbitration, like litigation, tends to run on, if you like, parallel tracks of a train line, in that both parties are looking to get to a certain point down the track, but they're not moving across, they're moving in a linear, parallel fashion towards the end goal, which is the arbitration or the arbitral proceedings. So in that sense, it's like litigation and very different to other forms of ADR. And it's adversarial. We're having pleadings, we're dealing with arguments where the lawyers for both sides present the case from their client's perspective. So I guess, except for court-ordered arbitration, there is the requirement for the consent of the parties. It is private, and the result is usually binding only on the parties to the case. So in other words, it doesn't have a precedent value. We're familiar through other courses that we've done at university to know that in certain courts, certain decisions of the court have a binding effect. Well, that doesn't apply in arbitration. So that's a difference between it and litigation, if you like. Experts are always a part of arbitration in the same way that they will be in litigation. All right, so we've talked briefly about the international sphere. What about the domestic sphere? Well, the Commonwealth doesn't have power generally to make laws in relation to arbitration. It does have power under Section 51(35), subsection 35, to make laws in relation to arbitration, but it's restricted to those disputes between employer and employee. The Commonwealth was instrumental in working with the states, at least those states have adopted this procedure, to introduce uniform commercial arbitration acts. So you'll see the CAA, the Commercial Arbitration Act. In Queensland, it's 2013. In other states, it's different years. Queensland was a little late to the party. So when we have the Commercial Arbitration Act 2013 in Queensland, it is really part of a uniform series of acts which are introduced in other states and territories of Queensland. So it's domestic to the state, but it has a flavour about it that is consistent around Australia. So the Commercial Arbitration Act of 2013 is the Queensland version of that uniform legislation. And that legislation, the Commercial Arbitration Act, is based in very many ways on the UNCITRAL model law that we talked about earlier. Okay, if you have access to a computer which will allow you to go on and access the legislation, you could do that now, because what I'm going to do is work my way through the Act largely. So if you've got access to the Commercial Arbitration Act, you'll see where we're going with this. All right, so the first thing is the paramount objective. Section 1AC of the Act provides that the object is to facilitate a couple of things, and these are important. So when you're thinking about resolution through arbitration, think about the objectives in 1AC. It must be fair, it must be final, and it must be a resolution of a commercial dispute by an impartial arbitral tribunal. And that arbitral tribunal must make its determination, its award, without unnecessary delay and without unnecessary expense. So do you get the feel for this? The idea is that it's meant to be fair, but it's final, it's binding, independent, as little delay and as little expense as possible. That's the idea. But we see that type of object in many pieces of legislation that bind courts and tribunals. For example, in the Queensland's Civil and Administrative Tribunal, there is the same overlying philosophy. So what does an arbitrator do? Well, the primary or preliminary obligation on an arbitrator is in Section 12 of the Act. And when I talk about the Act now, I'm talking about the Commercial Arbitration Act. And Section 12 of the Act says that the potential arbitrator must disclose issues that are potentially grounds for challenge. So if someone is proposed to act as the arbitrator, they must disclose, pursuant to Section 12, any circumstance that is likely to give justifiable doubt as to their impartiality or independence. That raises, in my mind, some interesting questions. If we have an arbitrator who is a person with expertise in the field, it may well be that that person has conducted a number of arbitrations, and it may be that they've become very familiar with one side of the dispute, in the sense that they have on many occasions been selected to act as the arbitrator for a company. The other side of the dispute may be a person who's involved in a one-off situation. So I wonder if that gives rise to a potential for doubts to be raised as to the impartiality or independence of the arbitrator if they're regularly having one side of the dispute appear before them in the arbitration and not the other. So think about those issues about what it is that an arbitrator might disclose to allay any concerns about bias or impartiality. So having overcome that barrier, we've approached an arbitrator and we've made a selection. What type of disputes does it apply to? Have a look at section 1, subsection 1, and you'll see that it applies to domestic commercial arbitrations. But the determination as to whether it's domestic is found in the same section, and really it talks about a connection to Australia rather than Queensland, which is interesting because it's Queensland legislation, but it still talks about a connection to Australia, and it can still then apply to Queensland. If you look at section 1, subsection 3, it talks about when an arbitration is domestic, because bear in mind, this Act only applies to domestic commercial arbitrations, not the international commercial arbitration that we talked about earlier tonight. So an arbitration is domestic if the parties to the arbitration agreement have, at the time of conclusion of that agreement, their place in Australia, and the parties have agreed that any dispute is to be settled by arbitration, and it's not an arbitration to which the model law, as given effect by the International Arbitration Act 1974, applies. So even though many of the things which are contained within the Commercial Arbitration Act 2013 are based on the model law, the arbitration will not be domestic if it's an arbitration to which the model law applies. I hope that makes some sense. So we're talking about an influence rather than a direct application of the model law. So have a look at section 1.1 and 1.3. That's critically important to determine the threshold question as to whether this is a dispute that is capable of being the subject of this domestic commercial arbitration. Now, the word commercial is not defined. Domestic is, but commercial is not. And if you look in Spencer at 4.50 of the text, Spencer says, I'll just read the words. This is paragraph 4.50. It says, interestingly, the names of the Act, referring to the Uniform Commercial Arbitration Acts, are somewhat of a misnomer, as there is no restriction to invoking the Acts based on the subject matter of the dispute. In other words, the Acts can be invoked whether the dispute is commercial in nature or not. The word commercial could be removed from the title of the Act and not affect the operation in the slightest. I'm not entirely convinced that's right. I mean, I think there's a good argument to say it is, but do bear in mind that at the bottom of the section 1, subsection 1, there is reference to a potential meaning for the word commercial because it does refer to the model law on which the Act is based. And there it talks about the commercial having wide interpretation to cover all sorts of relationships of a commercial nature, whether contractual or not. But generally speaking, I think we can take this from the commentary in Spencer, that the jurisdiction to deal with certain disputes is very broad if the parties want to go that way. So what's the challenge for you? The challenge for you is, I guess, twofold. You need to think about how you would advise clients that enter into a commercial arrangement, or indeed, if we adopt Spencer's approach, any arrangement where there is the potential for a dispute. And ask yourself, is it advantageous for my client to include a clause in the agreement which calls for the matter to be resolved through arbitration rather than litigation? And you won't be able to give that advice unless you have a good idea of what arbitration is all about, what it would cost, who you would approach to conduct the arbitration, What are the timeframes? What is the power available to the arbitrator? Does that suit your client? Things of that nature. So in other words, think about arbitration from the context of what it means to be involved in it, but just as importantly, think about it in terms of the context of how would I advise my client entering into a commercial or other arrangement. Okay, so let's assume for a moment then that we are involved in advising a client who is subject to a dispute, and the dispute is one where the parties have agreed to go into arbitration, or at the outset when they formulated their agreement they provided for disputes to be resolved by arbitration. Either way, the matter can go to arbitration. So the parties enter into an arbitration agreement, or perhaps even the court has referred the matter to arbitration under an Act. Have a look at Section 7 of the Act, and it talks about what we mean by the arbitration agreement. So it must be in writing. I guess that's pretty obvious, but and it can be in the form of an arbitration clause in a contract or a separate agreement. So it's very broad. So you're thinking about arbitration at a whole range of times when you're advising clients. Now, what if you have a situation where a client says, yes, I've agreed to arbitration, but I don't want to go to arbitration. I want to litigate. Litigation stronger, we can get a better result. Well, the problem is that where the parties have agreed to arbitrate rather than litigate, usually that election takes priority. In other words, if that's the agreement, the court will honour the agreement, even if it means stepping aside while the matter is arbitrated. In some ways, you know, this reminds me a little bit about the distinction, you know, in the 19th century about going to equitable courts for a remedy as opposed to going to courts of law for a remedy. That was all joined in 1873, but you know, there was that clear choice, and it's a little bit like that now. You know, do we go to arbitration or do we go to litigation? But if the parties have agreed to arbitrate, then that will take effect. If there's an agreement and one of the parties says, forget the agreement, I'm litigating anyway, then essentially upon request, the court must refer the matter back to arbitration unless the agreement is null and void or it's inoperable or incapable of being performed. Have a look at Section 8 in that regard. So what we've identified is that the courts will not intervene in arbitration in terms of overriding it and saying, well, we're going to litigate, doesn't matter what you've agreed to before. The courts still have a part to play in arbitration, but only to the extent that it's provided for in the Act. The inherent jurisdiction of, say, the Supreme Court does not apply to oversee arbitral procedures or arbitration generally. The Supreme Court has certain function, but you do need to look at the Act, and the District Court has certain jurisdiction as well. Have a look at Section 6 of the Act in that regard. So what is the ability of a court to intervene? It is compatible with an arbitration of agreement for a party to request a court to provide certain interim measures of protection, refer to Section 9 of the Act. And the courts do have power of oversight when a party challenges an arbitrator. So an arbitrator might be challenged, for example, if there are doubts as to the impartiality and independence, or if the arbitrator doesn't possess necessary qualifications that have been agreed to by the parties. Remember, I said that the arbitrator must make a statement pursuant to Section 12 as to impartiality and independence. Having received that, having started, if there's a challenge to that, then the courts can go behind that and make a determination. So refer to Section 12, subsection 3 of the Act. There are justifiable doubts as to impartiality or independence only if there is a real danger of bias on the part of the person conducting the arbitration. So if you're going to challenge an arbitrator's appointment, on the basis of lack of independence, you must overcome the threshold question the court will ask itself, and that is there a real danger of bias? Sometimes you might approach the court because the arbitrator has failed to act or just can't act. So if the arbitrator becomes in law or in fact unable to perform functions, then the arbitrator's mandate terminates. If the arbitrator withdraws, or if the party agrees on termination, or otherwise the court can determine the matter. Have a look at section 14 of the Act in that regard. I guess another thing that may crop up is a question about the existence or the validity of the arbitration agreement, or indeed the jurisdiction of the arbitrator. Have a look at section 16 of the Act. The arbitral tribunal may rule on its own jurisdiction, including any objections to the existence or validity of the agreement. Otherwise, the court can decide. Now, that's interesting. So what we're saying is this. You wish to challenge an arbitration agreement on the basis that it was not validly executed. You don't go to the court necessarily. You would go to the arbitral tribunal itself to make a ruling as to whether or not the arbitration agreement that led it there was valid. It's kind of a bit circular, isn't it? But that's the way you should approach it. And really, section 16 emphasises the need for the parties to a dispute to look at arbitration first before litigation. Look, there are some other powers that will allow the court to remove an arbitrator in certain circumstances. Okay, an interesting area. One of the deficiencies in arbitration prior to the introduction of the Uniform Acts was a real or perceived lack of ability to deal with interim measures. Interlocutory proceedings, such as preserving assets or preserving evidence. I trust that some of you have done civil procedure or not, or will be doing civil procedure. Really good subject, interesting subject. One of the important things that you need to bear in mind when you're a litigator is the need to preserve assets or preserve evidence. You might need to preserve assets if you have concerns, genuine concerns, that any successful judgment you obtain against the opponent may be a hollow victory because there's no assets against which to execute the judgment. Or it might be that in order to successfully make your claim, you must preserve the assets but preserve the evidence before they're destroyed. So if, for example, you're dealing with a copyright case, you want to make sure that the copyright material, which is said to have breached your client's rights, is actually available and not destroyed. So you can obtain certain orders. The orders that I want to talk about are now available to arbitrators as well, and they are freezing orders and search orders. So freezing orders, just by way of quick contrast and background, if you look at the UCPR Rule 260 Cap A, it deals with freezing orders. We call these Moravian orders or Moravian injunctions. Essentially, it provides this, that a court may make an order, the freezing order, to prevent the frustration of the court process by seeking to meet a danger that a judgment or prospective judgment of the court will be wholly or partly unsatisfied. So a freezing order is an order to restrain a respondent from moving an asset located in or outside Australia, or disposing or diminishing the value of those assets. If you're looking at Rule 260A, most definitely look at Rule 260B and Rule 260C, which deal with ancillary orders. And it's possible to make those applications ex parte. You don't have to give notice to the other side. In fact, that's really the whole idea of it. Also, have a look at Practice Direction number 1 of 2007, where it deals with Moravian orders, also known as Moravian injunctions, or asset protection orders or freezing orders. So we get the idea? So, having discussed Rule 260A, Rule 260B and Rule 260C in the practice direction that relates to litigation, have a look at Section 17(2)(c) of the Commercial Arbitration Act, and you'll see that the arbitral tribunal may make an award against a party to provide a means of preserving assets out of which a subsequent award may be satisfied. Looks very similar. So an arbitral tribunal does have the power to grant this very important interim measure that would otherwise be available to a court. So that's a freezing order. The other order, very important, is a search order, also known as an Anton Pillar order. And essentially this provides an opportunity for, in a proceedings or anticipated proceedings, for a party to secure and preserve evidence and permit people to search and enter premises for the purpose of securing and preserving that evidence. Have a look at Rule 261A of the UCPR. Also look at Practice Direction number 2 of 2007. This is the Supreme Court Practice Directions, and you'll see that this relates to Anton Pillar awards. So an arbitral tribunal also has power to make award to provide a means of securing or preserving evidence that might be relevant. Have a look at Section 17(2)(d) of the Commercial Arbitration Act 2013. But there are some conditions for granting those interim measures. Have a look at Section 17A(1) and 17A(2). Essentially, the party that requests these interim measures is required to satisfy the tribunal of certain things in much the same way that the party would have to satisfy a court seeking such interim measures. The party would have to satisfy the tribunal that harm is not adequately reparable by an award of damages. The harm substantially outweighs the likely risk, and there's a reasonable possibility that the requesting party will succeed. So you have to show a good case, you have to show good reason for it. But it's a discretionary matter. But keep that in mind. If you're advising a party going into an arbitration, do you need to preserve the assets? Do you need to preserve the evidence? And if so, are you prepared to do something about it? It's a big step. Whether you go to an arbitration or a court, Section 17 in the context of arbitration is very important. So have a look at that. Section 17 also provides for other interim orders that might be available, awards that might be available. So the arbitral proceedings on an interim basis can deal with security for cost, discovery of documents, giving evidence by affidavit, inspection of property, which forms part of the subject matter, taking photograph samples, or dealing with procedures at the arbitration, such as allocating time and having certain measures in place. A whole lot of things that you need to think about before you go into an arbitration. So, I mean, if you were given a question in your take-home exam that deals with the issue of how you would advise a client leading into an arbitration, these are all the things that you need to consider. Okay, so let's assume that we've gone past the interlocutory stage. We're now at the doorstep of the arbitration. Section 18 of the Act provides the basic requirement of arbitration. The arbitrator has to treat the parties equally. Compare that with the model law, which is Article 18. The arbitrator must determine the rules of procedure, model law, Article 19. That means the arbitrator must explain the procedure, but the parties appoint the arbitrator, so the parties get to say what the procedure would be by agreement. So there must be an arbitration agreement. And what starts the arbitration? You've got an arbitration agreement, you've got a dispute, maybe something is brewing. What's the trigger? Have a look at Section 21, and it provides that unless agreed by the parties, the arbitral proceedings commence when the respondent receives a request for the dispute to be referred to arbitration. It's as simple as that. It's just a matter of saying, we're going to arbitration. The agreement provides for it. I'm now giving you notice. Away we go. So when we get into the arbitration, there will be some procedural steps. We must appoint someone that's suitably qualified. Otherwise, the arbitration's void. So in that sense, there is a case in your text. It's called Oakland against Benham. It's 1953 to Queen's Bench 261. And consider that in that context. Sometimes arbitrators want to delegate their powers, they're only entitled to do that in certain limited circumstances. Essentially, it has to be authorised by the agreement itself. The general rule is that the arbitrator has to come up with his or her own opinion. So we've now into the arbitration. What powers does the arbitrator have? Well, the arbitrator has power to order disclosure. In other words, just like a court situation, if a party is not disclosing relevant material, you can approach the arbitrator and ask for an order for disclosure. And the arbitrator has power to make that order. The arbitrator can order disclosure from the power to do so in the agreement. And the orders that the arbitrator can make can be quite wide. For example, an arbitrator has power to dissolve a partnership. See, arbitration is a really good procedure, I think, for something like a partnership. So if in the exam question you've got to advise someone in a partnership situation or going into a partnership agreement about whether they should provide for mediation in the event of a dispute or arbitration in the event of a dispute, then if you think about the relationship of the parties, the commercial flavour of it perhaps, you might say that arbitration is the best way to go ahead of alternatives such as receivership or litigation. Arbitrators can, if given power to do so, grant equitable relief. So some of the orders that we've talked about on an interim basis are really equitable in nature. There is power to adjourn the proceedings, but that's not often invoked. In other words, it's only if natural justice dictates it's appropriate to do so that the arbitrator would consider an adjournment. Otherwise, if the matter's listed, it will proceed. And remember, once we get into that arbitration procedure, it is adversarial, which means that the arbitrator has a duty to allow for cross-examination of witnesses. And clients sometimes like that. You know, even though the mediation process is good, sometimes people do like their day in court. They do like to test the other side, and they do want their lawyer to be involved in cross-examination. So that might be something that's of use. We have the arbitration. The matter is determined by the arbitrator, and the arbitrator makes a decision reduced to writing, and it's called the award. What if you're not happy with it? Can you then go to a court and seek to set it aside? It's pretty limited. The court can only set aside an award if it's too wide, if it's privileged, if there's no jurisdiction. The arbitrator must decide things according to law. That's Section 21 of the Act. But it's very limited in terms of what can be done. So Section 34A deals with issues to do with questions of law generally, and the Act, Section 34, allows for an appeal on a question of law arising out of arbitral award, but it's limited in circumstances and only on an opt-in basis. So it's not there as a matter of right. The parties have to agree to that. A recent decision that I would urge you to look at, which provides you with a good basis for understanding the right of an appeal from arbitral award, is a decision of His Honour Justice Jackson in the Supreme Court. It's called Mango Boulevard Proprietary Limited against Mio Art, M-I-O Art Proprietary Limited. It's 2007 QSC, Queensland Supreme Court at 87. When you look at that decision, at paragraph 20, Justice Jackson adopts the words of the Chief Justice of Singapore, Menon CJ, in delivering a judgment in the Singapore Court of Appeal. And that case in Singapore is AKN and another against ALC and others, 2015 SGCA 63, that's Singapore Court of Appeal. The passage that I want to read to you is important because it shows the extent or limited extent to which parties have a right of appeal from arbitral awards. And this is what Manon CJ said. In particular, there is no right of appeal from arbitral awards. That is not to say that the courts can never intervene. However, the grounds for curial intervention are narrowly circumscribed and generally concern process failures that are unfair and prejudice the parties, or instances where the arbitral tribunal has made a decision that is beyond the scope of the arbitration agreement. It follows that, from the court's perspective, the parties to an arbitration do not have a right to a correct decision from the arbitral tribunal that can be vindicated by the courts. Instead, they only have a right to a decision that is within the ambit of their consent to have the dispute arbitrated, and that it is arrived at following a fair process. In light of the limited role in arbitral proceedings, the court must resist the temptation to engage in what is substantially an appeal on the legal merits of an arbitral award, but which, through ingenuity of counsel, may be disguised and presented as a challenge to process failures during arbitration. I really like that passage because it again emphasises the importance of what the parties have come to agree from the outset. If they want an arbitration, if they want a binding agreement, remember, go back to the principles of arbitration. Have a look at the objects of the Commercial Arbitration Act. Section 1, it's got to be fair, it's got to be binding, it's got to be as quick and cheap as possible. If that's what the parties agreed to, the courts will say, quite rightly, well, don't come to us if you're not happy with the result. Otherwise, you could have gone to litigation from the outset, if that's what you'd agreed to. Have a look also at Section 34 of the Act, which provides the only recourse for setting aside the award. Again, have a look at that Mango Boulevard against Mio Art decision of Justice Jackson. And that case also provides information about whether there has been a denial of natural justice or procedural fairness. Okay, I know I'm doing a lot of talking, but you're doing well. We're almost finished. So, what you need to do is, for the purpose of the exam or otherwise, put together a list of advantages of arbitration, disadvantages of arbitration, and think about that in the context of whether you would advise a client to go into arbitration, and if so, when, in what circumstances generally. It's a very broad statement to make. But if you fail to address the issue of arbitration when you are advising clients that are going into a commercial or other arrangement, you may be subject to criticism for failing to give them that advice and provide them with the option. And you can only provide them with the advice and the option if you know what it is. So I'm not going to give you a list of advantages or disadvantages. You'll need to create that for yourself. Just finally, going right back to the start when we talked about the international flavour of arbitration as opposed to the domestic, most of what I've been talking about tonight is the Commercial Arbitration Act, which is the domestic version. The international version is the International Arbitration Act, 1974, it's Commonwealth Act, and you can have a look, if you like, at the Australian Centre for International Commercial Arbitration. There's a website for the ACICA. It's independent, it's not-for-profit organisation, and it deals with international disputes. And under regulations, it was appointed the sole default authority to perform arbitration appointment functions under that international act. So if you want to be appointed as an international arbitrator, you will need to gain your appointment through reference by the ACICA. Okay. Any questions? Or have I just bombarded you completely? Again, you've done well to hang in there.
John?
Yes, yes, Paul?
The arbitration agreement, who draws that up? If you've got a client, if there's two of you going into an arbitration, then do the solicitors get together to draw it up? Is that the idea?
Yes, and the agreement can be contained in a clause which is in the initial partnership agreement, if you like, or it can be a separate agreement, typically drawn by lawyers, yes.
Right. So in contractual stuff, you often have an arbitration clause. You know, if parties don't agree on payments or something like that, then you can go to arbitration. You know, in a building contract, it'd be like an architect or something like that. Yeah. Okay. So it just depends on the area of expertise, I guess, in the area that you're working in for the arbitration.
That's right. That's right.
Okay, thank you.
Okay, thanks, Paul. Oh, look, I neglected to say that another area of practice where arbitration is becoming increasingly popular is family law. So it may be that parties to a property settlement would be better served by going through arbitration than litigation in the family court. That'd be a good exercise. That'd be a good exam question. See to what extent you can apply the principles under the Commercial Arbitration Act in a family law context and what discuss and distinguish. Just a thought. I may be giving you real hints, I may be giving you false hints, but you know, you can't have everything that I hint on the exam itself. Any other questions, comments? Thank you, Paul, for that. Yes, NASA?
Yeah, I just wanted to ask you about the confidentiality agreements. So does both parties sign the confidentiality agreement, and also the arbitrator, does he also sign, or she signs the confidentiality agreement as well?
Yes, that's right. Look, and I probably should have mentioned something about this. Have a look at sections 27E through to 27I of the Act. That deals generally with confidentiality. The parties and the arbitrator should sign that agreement. And the parties must not disclose the confidential information. I mean, the Act, I don't think the Act specifically says that about the arbitrator, but that...
But if we look at it in a different context, say there's an element of, say, criminality that comes up in the actual arbitration, does the arbitrator have to be impartial to that, or...
No, there's a general rule that applies that an arbitrator has an obligation to report certain things, not criminality as such, but criminality of a certain type where there is an imminent and real risk of danger or harm to others.
Okay.
No,
thanks for
point.
that, John.
Really good point. So have a look at sections 27E to 27I of the Act, and you'll see that that legislation reverses the position in ESO Australia Resources against Plowman, which was in 1995, 183 CLR 10, where the High Court had previously said that privacy in an arbitration should be respected, but confidentiality was not essential. So it's now been made essential through legislation, overruling. So the Act, of course, overrules, if you like, the High Court decision. Thank you, NASA.
Thanks, John.
Any other questions, comments? All right. Look, I just want to let you know, give you a heads up. Next week, we're going to deal with the whole range of areas. Collaborative law, the dispute resolution advisor, dispute review boards, partnering, appraisals, evaluations and determinations, court-appointed referees, adjudication, dispute resolution and criminal justice, which is a favourite of mine. And I'm going to get you to do some homework over and above what's in the material on Moodle in terms of thinking about it. So next week, we're going to try and make it a little bit more interactive because I'm sure that you're tired of just listening to me all the time. So if you're happy with that, we'll try and make it a bit more interactive. I'll set you some questions to ask yourself, and maybe we can have a chat about it next week. All right. Any questions about what we're doing next week? All good? And I hope that you're well advanced in your first assessment and enjoying it. I want you to enjoy that assessment. Every year people do. They enjoy it. Okay. No questions? All right. We'll stop for tonight. Thank you very much for attending, and we'll see you next week. All the best. Bye.
Thanks, John.